So beginning with the second article, that is justice delayed in market system. So that is, this article majorly focuses the leading editorial in the paper. This article specifies about role of judiciary in market economy. The one unique feature about this article is something very interesting, like where is judiciary and where is market economy. Market economy is purely related to the private forces, while the judiciary is related to dispute resolution. So there is something very more difference between two parts, but it is interlinked for the important issues in India in order to facilitate the economy. So this article specifies the unique features of that particular linkage, that is role of judiciary in market economy. So in this article, the author focuses on the important part that strengthening of judiciary can bring some major changes in the market economy in order to facilitate the economy in India. So in 1991, all of you have heard that in 1991 there we went for LPG reforms, that is liberalization, privatization and globalization. After this after this LPG reforms, we started to open up our economy by giving importance to the capital markets, that is open markets or private sectors flow. So after this 1990, we have seen many reforms in our economic system, that is like taxation reforms like GST, and in order to facilitate the economy, like we came back with insolvency and bankruptcy code. So even though by giving this much macro policies like GST and insolvency and bankruptcy code, the government, despite of bringing these changes, Indian economy has not reached its full potential, because ಈ ಥರ ಮಾರ್ಕೆಟ್ ಓಪನ್ ಮಾಡೋದ್ರಿಂದ ಅಥವಾ ಪ್ರೈವೇಟ್ ಪ್ಲೇಯರ್ಸ್ನ ಫೋರ್ ಫ್ರಂಟಿಗೆ ತರೋದ್ರಿಂದ what happens is, so after bringing all these changes, it has helped India to bring in the top 100 of ease of doing business index. So this index becomes very important for India, for it helps to make the more flow of foreign direct investments, where we get many investments in order to mobilize our economy to the greater level, which helps our economy to start from developing nation to developed nation. So with this perspective, government has brought many reforms like GST and IBC. So despite of these macroeconomic policies, Indian economy has not reached its full potential, because the government has neglected to strengthen the judiciary. So something I want to speak about, there is direct relationship with the judiciary, strengthening of judiciary and market economy. So this article focuses on this issue. So this part, what I spoke up till now, becomes the background of this context. Now let us come to the present context, where the role of judiciary is a very important part in a mobilizing economy or bringing GDP growth to the economy. So here, when it comes to the role of judiciary can protect the rights of private sector. If for example, if a company is investing in somewhere in India for manufacturing some goods, for instance, it property rights has to be protected, because it needs some legal protection from the government or from the country side in order to build this business in the particular country. So the role of judiciary is to provide these property rights to the private sector. Another is preserve sanctity of the contracts. If the contracts has been done, the contract should maintain transparency, or the bidding of contract should go in a sanctical manner, so that it needs some legal entity over here. So this sanctity can be preserved by the legal information which is provided by the courts. So again here the judiciary becomes very important. And third one is enforce and rights and liabilities of a parties. If example, if company A manufactures some product, it needs to be patented, it needs to be copyrighted, or it needs to be gets its own rights to market its products. So this particular legal protection for that particular product should be enforced by the rights which is provided by that judiciary, that particular judiciary in the country. So these three factors, one is protect, second is preserve, third is enforce, are the three factors which is needed to be provided by the judiciary of that particular country in order to mobilize economy by the private players. So, and the fourth important point by the judiciary which should afford for the private sectors the low cost dispute resolution mechanism is something. Nexus is present between the two companies or between the government or the government and the firm. The dispute resolution mechanism should be in an affordable way in order to solve the problem for the private sector either with the other firm or between the government. So this becomes very important. The judiciary should provide low cost dispute resolution mechanism for the private sectors, which helps them in getting better justice for their business. And another problem is that the unstrengthened judiciary in market economy has resulted in some negative shades for getting foreign investments, or the unstrengthening of judiciary has made some constraints for the economy to flow. So following are the constraints which where the judiciary is facing in order to mobilize the economy. Okay, first part let us look at the present status of dispute resolution mechanism in order to mobilize the market economy. First is, if there is any particular problem with the private sector in order to establishment of a business in India, the delayed justice given by the judiciary. So the data quotes that the cases remain, the pendency of cases is pending at least for 4.3 years in High Court. If company number A is facing some problem for establishment of his industry or manufacturing some product, or he is facing some legal problem, it takes 4.3 years in High Court in order to solve that particular case. So here the delayed justice, there is a sentence called as justice delayed is justice denied. That means miscarriage of the justice takes place when it is delayed. So delayed justice as is happening in India, and the pendency of cases to mobilize this market economy is delayed up to 4.3 years in the High Court. This is becoming one of the major constraint in India. Second is crony capitalism. Crony capitalism, the word crony capitalism is if there is a nexus between politics and political people and the market economy, there is a legal problems, or there is something ease of doing business. If the ease of doing business is absent between the government and the private sector, the projects or the manufacturing units or the manufacturing products get stalled, or the projects get stalled due to the crony capitalism, because there is a nexus between this political people and this laws and the market. So for this problem, for making huge profits, the market forces indirectly enter into the illegal means of doing business, where many of the works are getting done illegally. When the law is not permitting to do a particular business in a smooth manner, what the market forces do, they just try to bypass the system illegally or by providing some money like that, which makes the very grassroots of corruption. So again, the corruption becomes very problem here, and corruption starts from here. So this is the present status of dispute resolution mechanism in India, and reasons for this insufficient dispute resolution mechanism in India is quoted by Economic Survey 2018 and 19. There's a very important reasons where you can quote exactly in main answers. So when you quote the sources, or you quote the authentic references which you are justifying the reasons which you are writing in the mains examinations, gives weightage to your mains answer writing. So this reasons quoted by Economic Survey becomes very important for you people for writing mains examination, both in UPSC and KPSC examination. One is expansion of discretionary jurisdiction of High Court in under Article 226. For example, what I am telling is Article 226. Article 226 permits the High Courts to give writs in order to stop the violation of fundamental rights, or any other purpose. One is fundamental rights and any other purpose. Any other purpose. So this article mentions High Court can issue writs for violation of fundamental rights and for any other purpose. So this word any other purpose gives the interpretation of this line, gives the High Courts to issue writs in order to stall the private sector projects which is in violation with some market forces. So this article is providing something, is stopping stopping giving good justice to the market forces. And example, special leave petition of article under 136. So article 136 says that if Supreme Court allows to file a special leave petition, so that if you are not satisfied with the justice which is given by subordinate courts, whether it is High Court or whether it is a civil court, you can just go directly to the Supreme Court by taking special leave petition. So by taking special leave petition, what people do, people carry these cases to the Supreme Court directly by taking this provision which is provided under article 136, where again in the Supreme Court it results in the pendency of cases. What it happens when it goes with the pendency of cases, it will continue for many years to get it justice. And again I repeated, justice delayed is justice denied. So this is the problem with the insufficient dispute resolution mechanism which is available in the legal system of India. And other problem is there is only, for strengthening of judiciary, 0.09% of GDP is allocated for the strengthening of judiciary, where it is very much acute for the strengthening of judiciary. There is lack of staff in the High Courts and Supreme Courts. There is problem in the hiring of judges. There is number of judges per person is very less in India, where it's another big issue. And the allocation of budget to money in order to strengthen the judiciary is very less in this particular aspect. So these reasons are making for the insufficient dispute resolution mechanism in India, where it has stopped the smooth running of market economy or private sectors to participate in the country for the investments and the growth of the country. Coming to the next issue,